The day most people pay off their house, they think they have reached safety. I think they have reached visibility. That is the mistake. A paid-off house looks safe to the owner and irresistible to everyone else. It is not just a home anymore. It is a vault with your name on the front, your equity sitting inside, and in far too many cases, no serious lock on the door. If you are over 60 and you own your home free and clear, you need to understand something that most people never say out loud. You are not the least attractive target on your street. You are the most attractive one, not the family next door buried under a mortgage, not the renter across the street with nothing to seize you, the retired couple with decades of equity, the widow living alone in the house she finished paying for 10 years ago, the man who thinks low debt means low danger. That is who the wrong people look for. They do not look for noise. They look for exposed value. And a paid-off house is exposed value in its purest form. I have spent my whole life watching how money behaves when it sees weakness, confusion, delay, and paperwork. People forgot to file. Markets do it, creditors do it, governments do it, scammers do it fastest of all. They do not need to kick your door in. They do not need to wear masks. They do not even need to know you. In many places, they need nothing more than a public records search, a forged document, a county office willing to stamp paper without asking enough questions, and an owner who assumes that because a house is mine, it must therefore be protected. That assumption has ruined a lot of people. The source document began with a retired teacher whose house was effectively stolen on paper, not by a burglar, not by the bank, by a forged deed that was filed, accepted, and allowed to sit there until she fought her way back to what was already hers. She spent thousands in legal fees proving she owned her own home while a free alert system existed the entire time that could have warned her almost immediately. That is the kind of story people dismiss because they want it to be unusual. I would not dismiss it, I would study it, because the story is not really about one woman. It is about a system. And the system is brutally simple. If your house is paid off, searchable, untended from a paperwork standpoint, and attached to an older owner who assumes nobody is looking, then the wrong person does not see a house. He sees unlocked equity. That is why I want to give you the framework the right way. Not as a cheerful checklist, as a defense protocol. The first identity shift you need is this. A paid-off house is not the end of the financial game. It is the beginning of asset defense. Most people never make that transition. They spend 30 years trying to own the property. Then they spend the next 10 pretending ownership. And protection are the same thing. They are not the same thing. Ownership is the prize. Protection is the work that keeps the prize from being clawed back by paperwork, fraud, liens, taxes, probate, or negligence. If you remember nothing else from what I say, remember this. A house can be fully paid off and still be dangerously unsecured. Now let me tell you how I think about the threats. Because once you understand the threats, the documents stop looking like tedious forms and start looking like locks. There are 3 broad hands that can reach for your equity. The first hand belongs to scammers. The second hand belongs to creditors. The third hand belongs to government. If you do not understand all 3, you will protect against one and get blindsided by the other 2. Scammers want to move fast. They are looking for speed, confusion, and paper trails that can be manipulated before the owner notices. Creditors want legal access. They use judgments, collection actions, and claims that attach to whatever equity is left exposed. Government does not need stealth at all. Government uses statute, lien priority, deadlines, delinquency notices, and the ancient habit people have of ignoring official mail until the problem has become expensive. The 5 documents in your source material matter because together they create a layered defense against all 3 hands. I am going to explain them in the way I would explain them to a family member whose house I wanted protected by the end of the week. The first lock is the homestead declaration. I would go so far as to say that this is one of the most neglected pieces of defensive paperwork in America. That neglect is astonishing. When wealthy people buy a house, somebody on their side usually handles this kind of filing before the ink is dry. It gets treated as routine. It is filed, recorded, and forgotten, which is exactly how good defensive paperwork should feel. Quiet, uneventful, done. Ordinary homeowners do not get that treatment. They get silence. Nobody tells them that in many states the law allows them to protect a meaningful amount of primary residence equity from unsecured creditors by filing a simple homestead declaration. Read that carefully, not from the mortgage company, not from a tax lien, not from every threat under the sun, but from many ordinary unsecured creditor situations that can otherwise attach themselves to the equity people thought was untouchable. That matters a slip. And fall judgment matters. A medical debt that turns into aggressive collection matters. A civil judgment matters. A personal debt dispute matters. People hear the word creditor and imagine some exotic high finance event. Usually it is much uglier and much more ordinary than that. Someone sues, someone wins, someone records, someone goes looking for exposed equity. If the law in your state allows a properly filed homestead declaration to shield some or all of that equity from many unsecured claims, then failing to file it is not prudence. It is negligence. And negligence around valuable assets is expensive. What I like about this first lock is not just that it can protect money. It also changes the equation before a fight even starts. People are bolder when they think the target is soft. They are more cautious when the law has already been used against them in advance. That is how good defensive planning works. It changes the battlefield before anybody arrives. The precise protection amount varies by state. Some states are generous, some are stingy, some are spectacularly protective for a primary residence. But the deeper point does not change. If your state offers any meaningful homestead protection, and you have not filed it, you are voluntarily leaving equity exposed that the law may already be willing to defend. I do not like voluntary exposure, especially not when it can often be reduced with one notarized page and a county recording. Notice what this first lock also teaches you. It teaches you that home equity is not protected just because it feels morally protected. The law does not care how hard you worked. The law cares what was filed. The second lock is the property fraud alert. This one should make people angry because it reveals how preventable some of the worst stories actually are. The fraud playbook described in the source is disturbingly elegant. A scammer checks public records. He finds a free and clear property. He identifies an older owner. He forges paperwork. He files it. The office accepts it. Then he borrows against the property, tries to transfer it, or creates a problem large enough that the real owner has to pay lawyers just to untangle something that should never have happened. There is a sentence buried inside this entire issue that I want you to hear in Buffett language. A paid-off house without monitoring is an unguarded vault. Not because the walls are weak, because nobody is watching the door. That is what a property fraud alert corrects. It does not make fraud impossible. It makes fraud noisier. And noise is exactly what a scammer hates. If a county offers a free alert system that emails or notifies you when anything is recorded against your property, then that is not some optional digital convenience. That is an alarm system for your title. It takes minutes, it costs nothing in many places, and it can compress the distance between the fraudulent act and your response. That compression matters when people discover fraud months later. The fraud has roots when people discover it in a day. The fraud often has paperwork and very little else. The difference between the two is measured in legal fees, stress time, and sometimes whether the matter becomes a nightmare at all. If I owned a paid-off home and I knew my county had a property fraud alert program, I would not wait until tomorrow. I would register today, and I would tell everyone older than me and everyone younger than me with elderly parents to do the same. Because this is the kind of free defense that people ignore for the worst possible reason. It looks too easy. Easy does not mean unimportant. Sometimes the easiest move is the one that should have been made first. Now I need to move to the third force in this story because too many homeowners think the real danger is always some criminal outsider. Sometimes the danger is a government letter you did not open. That brings me to the third lock, which in one sense is not a document you file, but a status you must constantly control. Your tax position. The source was absolutely right to stop and talk about the IRS, because federal tax liens do not care about your feelings, your age, or your state homestead rules. People misunderstand tax problems because they imagine them arriving with fanfare. Usually they arrive with envelopes. An estimated payment missed here, a Roth conversion mishandled there, a surprise tax bill after some event in retirement, a lump sum distributed and under withheld, a letter unopened, a second letter postponed, a bill left alone because the owner assumes he will deal with it after the holidays, and that is how a tax issue becomes a lien issue. Once you understand that federal tax liens can attach to your property and that federal collection rights can override the warm assumptions people have about state-level protections, you stop treating tax compliance like paperwork and start treating it like perimeter defense. That is the right mentality. You do not need to be terrified of the IRS. You need to be current. Those are different things. Fear leads people to hide. Discipline leads people to open the letter, face the problem, arrange the payment plan, and prevent escalation. An installment agreement may not feel heroic, but it is often infinitely better than silence. Silence is where liens breed. If someone asked me for the Buffett version of tax defense in retirement, I would say this: do not let a solvable tax bill become a title problem, because once a tax debt has matured into a lien, the conversation changes. The sale of the property changes, the refinancing conversation changes, the balance of power changes, and homeowners who thought they were discussing paperwork are suddenly discussing their house. That is why the tax side belongs inside this defense protocol, not outside it. Now let us move to the third actual document lock in the source: enhanced title insurance. Most homeowners have title insurance and still do not understand what kind they have. That is a terrible combination. They have a vague memory of signing documents at closing, a hazy assumption that title insurance covers the house, and no precise idea of what period of time or what category of fraud it actually protects against. Vagueness is dangerous around contracts. What the source makes clear, and what I want to sharpen, is that standard title insurance is mostly rear-facing. It deals with problems rooted before you bought the property, hidden defects in the chain before closing. Earlier forgery, pre-existing title issues, that is useful, but it is not the same as being protected against future fraud after closing. A lot of people own a standard policy and mentally promote it into a magical shield that covers anything ugly that ever happens to title at any point in the future. That mental promotion is fiction. Enhanced title insurance is where the posture changes. Now, you are asking about post-closing threats, future forgery, identity-based transfers, fraudulent conveyances that emerge after the date everyone signed, and the legal cost attached to fighting those. Those costs matter more than people admit. You can be correct and still be financially mauled. That is one of the cruel truths of the legal system. Winning and affording the win are not always the same thing. So when someone says enhanced title insurance costs money, my reaction is simple. Of course it does. Protection usually costs less than repair. The right question is not whether it is free. The right question is, what kind of future fraud risk are you personally carrying? What does your current policy actually cover? And what would you be forced to pay if you had to litigate a forged deed issue without that extra layer? I like questions that force reality into the room. Here is one. If you received a phone call tomorrow that somebody had recorded a fraudulent document against your property, would your current policy help pay for the fight? Or would you be paying out of your own checking account while trying to prove the obvious? Most people cannot answer. That alone tells me they need to make the call. Not next month, this week. Find out whether the policy is standard or enhanced. Find out what an upgrade means. Find out before the problem exists. That is how adults handle risk. The fourth lock is the revocable living trust. People often misunderstand this one too because they want one document to do every job. That is not how serious planning works. A trust is not the same as a homestead declaration. A trust is not a substitute for tax compliance. A trust is not some mystical anti-creditor cloak that automatically makes all threats vanish. What it does do, when set up and funded correctly, is profoundly important. It can keep the home out of probate. It can add a layer of privacy and complexity that makes quick targeting harder. It can control what happens at death without forcing the family through a slow, public, expensive court process. And in some circumstances, especially when combined with competent estate planning in states with their own inheritance or estate taxes, it can prevent a lot of unnecessary damage. I have never met a scammer who loved complexity. I have never met a probate process that moved too fast. I have never met a family grief situation that improved because the court calendar got involved. That is why I like trust planning when it is done properly. It reduces exposure on several fronts at once. The source makes a subtle but valuable point here. When the house is titled in the trust, the public record presentation changes. Your personal name is not sitting there in the same naked way as direct title. That does not make you invisible, but it can make you less immediately convenient to the wrong person doing a fast search for low friction victims. Convenience is what criminals love. Delay and complexity are what they skip. There is also a second and deeper advantage when a person dies with a house in his own name and no proper trust structure. The family often gets dragged into probate, which is one of those institutions many people manage not to think about until it is too late. Probate is public. Probate is slow. Probate is procedural. Probate charges money to move your own property through a court because you failed to structure the transfer ahead of time. I prefer structure ahead of time, always. The other point the source made, and made well, is that a trust nobody funded is a theater prop. A shocking number of people pay for trust documents and never retitle the property into the trust. That is like paying for a safe and leaving the cash on the table. If you have a trust, confirm the deed was actually moved. Do not assume. Do not vaguely remember, confirm. If there is one phrase that belongs in all serious asset defense, it is this: trust. But verify is too weak. Verify, then trust. The fifth lock is the tax redemption record and the whole property tax delinquency timeline. This one cuts straight through complacency because it shows how quickly small neglect can become existential. People think of property taxes as routine, predictable, and therefore harmless until they are not. They are right up until the moment they are disastrously wrong. The Supreme Court case discussed in the source should have rattled every homeowner in America, especially older ones. Not because the specific facts will repeat in identical form in every county, but because it exposed something chillingly simple. Government error or overreach around delinquent property taxes can strip out enormous value if the owner does not intervene in time. Even where the law now says surplus equity must be returned, implementation is messy, timelines vary, and the redemption window still exists. That window is what matters. A lot of retirees do not lose control because they are reckless. They lose control because they are grieving, sick, overwhelmed, confused by notices, or still operating under the outdated assumption that they will work with me later. Maybe they will, maybe they will not. The calendar is not sentimental. If property taxes become delinquent and the process begins, you need to know your county, your notices, your state rules, your deadlines, and your right of redemption as though your house depends on it. Because it does. This is also the point where many homeowners miss an upside that is almost as maddening as the downside. Senior property tax exemptions, the source lists examples from several states, and the lesson is bigger than any one state. Many retirees are overpaying property taxes simply because they never applied for benefits they were already entitled to. I dislike overpaying anything, but overpaying taxes on the roof over your head because nobody told you a senior exemption existed is an especially bitter form of waste. When a county or state offers a reduction, freeze, exemption, or special treatment for older homeowners, that is not trivia, that is a recurring improvement in cash flow and risk reduction. Remember the main thread here. This is not just about saving money, it is about lowering the chance that future strain ever pushes you toward delinquency. Notices, panic, or forced decisions. Every dollar you never had to pay unnecessarily in property tax is one less dollar that can become a problem later. That is why I would tell an older homeowner to think of this fifth lock in two parts. First, avoid delinquency like poison. Second, claim every lawful exemption like a responsible owner. That is not greed, that is competence. Now I want to pull the whole protocol together because facts are only useful if they turn into action. If I were sitting across from an older homeowner over coffee and I had 1 hour to help protect the house, I would say this. First, stop calling the house safe just because the mortgage is gone. That language is sloppy and dangerous. Start calling it exposed equity that must be defended. Language matters because it changes behavior. Second, file the homestead declaration if your state provides meaningful protection and you have not already done it. Do not debate it forever. Research it, verify it, file it. Third, sign up for the county property fraud alert. If your county offers it and you are not enrolled, you are choosing silence where alarm is available. Fourth, understand your tax status with the seriousness of someone who knows federal and local tax problems can become title problems. Open the letters, fix the issue, use payment plans when necessary. Do not drift. Fifth, call and determine what title insurance protection you actually own and whether future fraud coverage exists. Sixth, establish or verify the revocable living trust and make sure the deed is actually in it. Seventh, check your property tax exemptions, delinquency status, and redemption rules. This is what separates people who keep their assets from people who merely assume they will. I call this the paper fortress. That is the master metaphor I would use for the whole thing. Most people think a house is protected by walls, locks, cameras, and insurance. Those things protect the physical house. The equity is protected by paper. The title is protected by paper. The probate path is changed by paper. The creditor exposure is reduced by paper. The fraud detection begins with paper. The tax status lives in paper. The tragedy is that people who would never leave their front door open all night routinely leave the paper fortress half, built for years. Then, when something happens, they say no one warned them. I am warning you now. A paid-off house is not a fortress unless the paper fortress exists around it. I also want to say something blunt that many people need to hear. You do not need to be wealthy to do this. That excuse does not work. Most of the locks here are cheap or free relative to the value they protect. What they require is not wealth. They require seriousness. That is a much fairer test. Some people with modest means are very serious and keep everything. Some people with far more money drift into preventable trouble because they confuse comfort with structure. I have seen that pattern in every asset class of my life. Money without structure invites loss. Structure without drama preserves money. That is what we are doing here. Preservation before panic. Preparation before grief. Paper before problem. The last identity flip I want to give you is this. If you are over 60 and own your home, you are not just a homeowner. You are a custodian of a multi-decade store of family stability. That house is not just your residence anymore. It is accumulated labor. It is compressed sacrifice. It is the result of decades of payments, repairs, delayed consumption, and often the best financial discipline of your life to leave that exposed, because the forms felt tedious would be irrational. To lock it down is not paranoia. It is stewardship. That is the word I prefer. Stewardship, because once you think like a steward, all 5 of these documents stop feeling optional. They become duties. And duties done on time are usually cheap. Duties done late are expensive. So here is how I would end it if I were speaking directly to someone who is 60, 70, or 80 and still believes this can wait. Do not wait for the suspicious letter. Do not wait for the forged filing. Do not wait for the delinquency notice. Do not wait for the lawsuit, the collection call, the attorney invoice, or the death in the family that sends the house into probate confusion while everybody is grieving. Build the paper fortress while the house is still quiet. File the lock before somebody tests the door, because the people who keep their home are rarely the people who meant well. They are the people who filed on time.